I'm delighted to have the opportunity to address you all today. Thank you, Patricia, for the introduction, and it's a privilege to be here amongst such distinguished speakers. I'd like to qualify my introduction by saying I'm quite a junior lawyer. I did only practice for about 4 or 5 years, so you'll have to keep that in mind when you're asking me questions. Having said that, my background is in child protection, so I suppose in terms of the work with the Coalition, the practical elements of having had children as clients, both in the criminal context in the children's court and representing guardian ad litems in the child protection sphere has been very helpful in understanding the mental health issues. So you all have the submission of the Children's Mental Health Coalition to the review of the Act in your packs. I'll bring you through some of those recommendations today, but I just want to start firstly by welcoming the interim review of the Act and the amount of considered thought that has gone into it. We had a meeting with the group that are the review group of the Act back in November, I think, and we had 2 young people as well as some members of the coalition come along with us to the meeting. And certainly from my perspective anyway, the views of the 2 young people that were there said so much more than anything I could have put down in a paper or a submission. And it just really brings home to you the importance of nothing about us without us, and the whole concept of participation, Article 12 of the UN Convention on the Rights of the Child, and the voice of the child. It's going to be so important in the upcoming debate about the Constitution. And I suppose, it just would be really to urge the Department in the next phase of the review to, in as much as they possibly can, to include the voice of the child and consult with a wide range of children from different socioeconomic backgrounds and from different experiences in terms of their experiences both of the Act, but also generally in using mental health services and what their experiences are, because I think it's only really in truly, adhering to that concept of participation and in actively including the child that we'll really get it right. So I just want to introduce you to the Children's Mental Health Coalition. Basically it has been around, the manifesto is from 2009. There's about 54 organisations in the coalition now, but it was really Amnesty International and the Children's Rights Alliance that came together initially, recognising that the whole area of mental health I suppose fell between stools a lot within the sector. There was a huge level of interest, so we have about 54 organisations now, but we also have a wide range of different individuals and professionals who, while they're not member organisations, they certainly input into the coalition's work quite a lot. So mental health professionals, including psychologists, psychiatrists, psychiatric nurses, social workers, lawyers that work with children, lots of different interested individuals. So that brings a great richness in terms of their experiences and input. And I'm delighted to see some members of the coalition here today. Our current priorities are, there's 3 different priorities. We've 3 different subgroups now in the coalition. Back in March we had a seminar in mental health and education, and that's a very important issue for a lot of our members. Again, that the Department of Education would really prioritise mental health and wellbeing as part of its remit, as a core part of its remit, a whole school approach, and also mapping out referral pathways for schools and giving support to schools on how to deal with students that might experience mental health problems. Secondly then, in relation to mental health services, it's really focusing on the extension of community mental health teams, that there would be the full complement of the recommended 99 teams that is recommended in a vision for change, and I'll talk a little bit more about that, but also it's access to those teams. And I think, as most of you will know, there's significant difficulties, particularly for 16 and 17-year-olds in accessing teams, and there's also still issues with waiting lists, even though an awful lot has improved. And the third area then is in relation to, and it's our key area of priority, is in relation to the mental health needs of vulnerable children, particularly children in the care system and children in the youth justice system. So we've identified that within the coalition as an area that there is no coherent government policy dedicated to these children. Again, I'll speak a little bit more about that, but I think in the week that's in it, where we've had the publication of the Child Death Review, I think everybody can recognise, certainly, and there's evidence of it there in the report, that many vulnerable children are falling between stools. And it's not only children in care and in detention, it's also children who perhaps have come to the attention of the HSE but have not been taken into care, homeless children, asylum-seeking children, children living in direct provision. In terms of the detention, children in detention, it's also children who are not in detention but are in and out of the children's court every day of the week. And these are our most vulnerable children. They're children that often end up in inpatient units. They're children that end up in secure care units. They're subject to very serious and very expensive legal proceedings. But we have not got it right in terms of identifying their mental health needs. A lot of these children have unmet needs. They have unidentified needs, and there's a complexity to their needs in that they also sometimes have complex behavioural and addiction problems. So I think this is a very important issue, and certainly from the point of view of the review of the Act, there's huge interplay between the area of children in care, children in detention, and children in inpatient units. And I'm glad to see that the review of the Act has addressed the issues in relation to the Child Care Act and the Mental Health Act. So, just I suppose to set the scene in relation to the provision of mental health services in children, I'm going to see, can I find my holding slide now? I have to apologise that I don't have any fancy PowerPoint presentation for you. Slight mishap with that this morning that I won't go into, but I'm just going to speak to you from my own notes. So, just in relation to the provision of mental health services in children, there has been huge progress, and gladly we have the CAMS reports, the annual child and adolescent mental health reports, that do provide us with significant data in relation to children who are accessing mental health services, and that is a hugely useful resource. The third annual report does show that there has been significant improvements in terms of the numbers of children on waiting lists. The number of children waiting over a year has reduced, and children waiting over 6 months has reduced. But there's still significant waiting times. I don't have the figures here now in front of me, but there's still significant numbers of children waiting, certainly 6 to 9 months and 3 to 6 months. And I know the Specialist CAMS Advisory Group has set 3 months as their ideal time, but no child will be waiting more than 3 months. Now, they're very far off that ideal, and certainly when we're talking about the passage of time for children, I would still think that 3 months is still a long time for a child with mental health difficulties to have to wait. So there has been improvements. Certainly the provision of inpatient beds for children, as a lot of you will know, has improved. I think there was a number of years ago when I was working in this area, there was only 13 beds in the country, and now there's 47 at the moment. So there has been some improvements. But just to flag some of the biggest gaps for you, the issue of 16 and 17-year-olds is still a huge issue. And within the CAMS reports, you can see that the vast majority of community mental health teams around the country do not provide access to fresh cases, so new referrals of 16 and 17-year-olds. They still cannot get access to community mental health services, and this is a very, very serious issue. The staffing of the existing multidisciplinary mental health teams. So there's 56 existing community mental health teams around the country. Out of recommended vision for change is 99, including both CAMS and community CAMS. 56 existing teams. Of the existing ones, their staffing levels are at 62%. So that has a significant impact on the ability of children to access the teams and also on waiting lists. In terms of the 150 posts that have been promised, which is obviously a very welcome development in the last budget, certainly there's an indication that those posts, when they are appointed, will be at a basic grade level. And I suppose when you're talking about the complexity of the cases in terms of 16 and 17-year-olds that these teams face, there is a concern within coalition members that to fully to staff teams to their full complement, there is a need to have very experienced staff in those posts to ensure that they can provide access to 16 and 17-year-olds and to those with complex needs. As I've already mentioned, one of the key issues is the lack of coherent policy in relation to children in care and children in detention. The Minister announced, was referred during the week to their plans to have, it's called ACTS, an Assessment, Consultation and Therapeutic Service for Children in Detention and Children in Care. And this is a welcome development, as children in detention and care traditionally have not had access to multidisciplinary mental health teams. However, as a coalition, we would have concerns that you cannot really address this issue in a vacuum. So putting multidisciplinary teams into detention schools and into secure units in circumstances where these children, when they're released, won't have access to post-follow-up support, perhaps because they can't access their local community mental health team, or because maybe traditional mental health services are not designed to meet the needs of these children. So providing a letter to a severely A child who's in homeless, perhaps in and out of crisis intervention, has a very chaotic life, and providing a letter to say turn up at the Mater Cams at 11 o'clock is not going to meet the needs of that particular child. So these are all the things that our members are very concerned about. I suppose that some of these don't directly relate to the review of the Act, but it's just kind of to set the context. I suppose everybody here in the discussion was saying, you know, we need to relate it to the reality and the situation on the ground for people. Again, just in terms of gaps, children with eating disorders, children with autism and other intellectual disabilities, again, the recommendations for Vision for Change haven't been implemented. With the reconfiguration of disability services that's happening at the moment, there hopefully will be some improvements there in terms of access to mental health difficulties, but that's, as of yet, we don't know that. The provision of inpatient beds. We know there has been improvement in terms of the numbers of children that are detained under the Act, either in voluntary or involuntary detention. The numbers in adult units has reduced. There's a much bigger proportion now in child and adolescent units, and that's very welcome. But I suppose there's a couple of issues there. Firstly, without fully staffed multidisciplinary teams with full access for children, we are going to continue to see large numbers of children in inpatient units. Whether that be, even if that is in a child-appropriate unit, I suppose, for children you'd be talking about the earliest possible intervention for the child. You're talking about treating the child in the most appropriate environment, in the closest environment to its home, in a child-centred way. And I suppose it's good to reflect on the cost to the state of keeping a child in an inpatient unit, be that a mental health unit or in a secure care unit. And there is always going to be children in crisis, and of course our members would acknowledge that. But certainly there are situations arising where children are ending up in inpatient units, perhaps because they didn't have access to care earlier. And that is a significant failure of the state in that regard. I think also the transition to adult services is a significant issue, and I know the young people that attended the review of the Act certainly raised this as an issue. And the young people that we speak to, that is certainly one of their biggest concerns. There is lots of brilliant practice out there within CAMS teams, and certainly some of the young people that we've spoken to have had excellent services within their CAMS teams with professionals that do consult them, that listen to their voice, that they've had a really good experience, very positive experience, and then all of a sudden they're 18, and I know there's research being done at the moment by Dr. Niamh McNamara and ECD on the absence of protocols in terms of transitioning from child to adult services, and that certainly is a very significant issue. I think in relation to children detained under the Act as well, if you think about the whole concept for a child being in a child unit and what that means, and then all of a sudden transferring to an adult unit and how frightening that must be for a child. So these are all issues that are very significant. There's certainly, I suppose, a move internationally towards the reconfiguration of mental health services to meet the needs of children and young people from 16 to 24 up. And I just want to draw everybody's attention to the My World survey that Headstrong published recently, which is a fantastic resource in that, I suppose it gives us a picture of the prevalence of mental health in Ireland. And it also looks at positive domains as well as negative domains. It looks at help-seeking behaviour. But it just demonstrates the emerging mental health problems, the ages that, 16 to 24 is a very significant age for the emerging of mental health difficulties. And we really need to think about that in terms of the design of our services and access to our services. So I suppose in just setting the context, the lack of interdepartmental cooperation would be the key thing that the Coalition would identify in terms of the gaps that they see, that members see. So I suppose the new Child and Family Welfare Agency, that there's a lot to talk about during the week, and while there's a welcome new focus on child protection, getting things right, I suppose we would be concerned that mental health wouldn't be lost within that. And when you're screening children or assessing children in terms of risk assessment for child protection, as was highlighted by the Child Death Review, this should always include an assessment of a child's mental health and emotional needs at a very early stage in terms of the initial assessment. I suppose until we have that right, with the new child protection standards, as a coalition we've made a submission to HICWA in terms of the draft standards, that they very much, the initial assessment should include an assessment of mental health need, because if that is there in the standards. It has to transfer into a care plan if a child is brought into care, and then that's subject to inspection under the new child protection regime. But just generally, I suppose, interagency work between the Department of Children, the HSE, the Department of Health, to include both health promotion and CAMS. Within the Department of Children, we have the Irish Youth Justice Service. Within the Department of Justice, we still have policy for youth justice retained in the Department of Justice. And within the Department of Education, we have the National Education Welfare Board and we have NEPS. And one of the issues raised in the Child Death Report during the week in terms of the mental health issues were the fact that red flags were being picked up upon. And one of the biggest red flags that they identified was simply a child that's not attending school. And I suppose we have to ask ourselves, in relation to how mental health is or is not being addressed in our education system, are schools supported to be able to help children who are experiencing mental health problems? I mean, certainly our members would say that they're not, and the new guidelines that are being developed by the Department of Education in relation to whole school approach to education will need to look at what is the role of CAMS and NEPS in supporting schools, how do they work together with the National Education Welfare Board to identify whether children who are excluded from school or not attending school have mental health needs and whether they're being assessed and followed up on for support. I suppose all of this as well highlights one of Amnesty's main recommendations and one of the coalitions in relation to the review of the Act, and I was delighted to see this highlighted in the interim report, the need for legislation and a statutory underpinning for the provision of community mental health services in Ireland, because as we've seen, there have been commitments over the years in budgets to mental health services, but we all know that mental health services has been the Cinderella of the health services, and children's mental health services has been severely disadvantaged in this regard as well. And even though there have been improvements, I think unless there is a protection in legislation in terms of putting a statutory obligation on the state to provide for these services and to map out their implementation plan for Vision for Change, we're not going to have proper accountability for this. And I suppose it's difficult as well in terms of the provision of inpatient beds for children, and that's where the pressure points always are, and the cost of that to the state and the cost of staff in each one of those beds. But, you know, one or two of those beds would staff a whole multidisciplinary community mental health team. So these are the kind of anomalies, the kind of difficulties that we're faced with, and I think we have to think as a society what kind of mental health services we want our young people to have access to. I was very interested to hear in the discussion people talking about getting a life sentence. It is important not to pathologise children, but I think the best way to ensure that children are pathologised is to ensure that they have the earliest possible intervention in circumstances where it's as close to their home and their family and their school and their community as possible, so as to ensure they're not ending up in a crisis. And I suppose when children are in a crisis, and that inevitably does occur with a number of children, families should be supported to support that child as well. And we have to ask ourselves about whether it would be possible in circumstances where a family isn't able to support the child, to provide help in the home for that family, be it a psychiatric nurse, maybe having mental health professionals calling daily, including social workers, to the home. So there's all sorts of different ways we can look at it in terms of the delivery of services. So just moving on to the Mental Health Act, the title of my presentation is Children Seen and Not Heard, Unseen and Unheard. So the standalone section in relation to children that you'll see in our submission in relation to the Act, we're delighted to see that has been recommended in the interim review. I suppose it's to make children more visible within the Act, and also for mental health professionals that they can take this piece of legislation without having to go to another piece of legislation and understand and know what their obligations are. And for children and families to be able to understand that. I think a child-friendly version of the Act is also very important, and you know, we're great in this country at writing legislation that nobody can understand, nobody that it refers to can understand it. So it's very important that there would be a plain English guide to the legislation, and I was delighted to see recommended that information, accessible and appropriate information be available for children. In relation to the human rights principles, I suppose I was again pleased to see that the concept of best interest mentioned in the interim review in terms of deciding in relation to the admission of a child. But just in terms of the terms that are the reference section or the guiding principles that are recommended in review of the Act, we see the welfare principle then the welfare of the child is the first and paramount consideration. I suppose I just wanted to talk a little bit about the concept of the best interest of the child and why that's a better phrase to use than the welfare of the child. I think particularly now when we're going to have the debate on the upcoming constitutional referendum, and hopefully when we see wording, it will include a best interest provision, it will include a voice of the child provision and a standalone statement that children are individual rights holders. But the best interest principle, I suppose, it comes from Article 3 of the Convention on the Rights of the Child, and it's a procedural right rather than a kind of a substantive right. I don't want to get into kind of technical legal definitions or anything like that, but I suppose what I wanted to say is that the reason it's a better term to use than welfare is because really it puts it in the context of the Convention on the Rights of the Child as a whole. So you can't consider best interests in a vacuum. It belongs to a larger entity of the Convention on the Rights of the Child, and it establishes a new status on the child as an individual that is subject to rights. And this confers a particular dimension. It links it to other general principles within the Convention on the Rights of the Child. So where welfare of the child is an Irish law concept, it's quite a paternalistic concept, and it's quite, I suppose, a subjective concept that has been applied by judges and decision makers over the years. The best interest principle, it's a different dimension. It also links it to the general principles of the Convention, Article 2, non-discrimination, Article 6, which is the right to life and harmonious development, and Article 12, very importantly, the right to be heard and have the child's views considered and duly weighted. So it also puts an obligation to consider best interest in the context of all of the rights in the Convention on the Rights of the Child. So Emily Logan, I thought, put it very well. She gave a paper at a legal medical conference a few months ago, and she talked about how really when challenges arise for health practitioners in relation to best interests, they can be mitigated if you use an inclusive approach which allows children in line with their maturity and capacity the opportunity to express their views and decisions concerning their health. So ultimately the child's view is not the only aspect of decisions that are going to be considered. Of course there are other rights, and the parents' rights are of course within the context of that, but if participation as a right is respected in a meaningful way, this has to change the nature of the best interest test. So it gives the possibility that the child's views, they may not be able to be acceded to, but in some cases this shouldn't negate the process whereby their views have to be heard in the first place. So it's just important to respect that process of consulting the child. Just also in relation to best interest principle, I suppose it's very often criticised, and you're going to hear a lot of criticism about it when the debate and the referendum starts, and people who say it's a vague term, it can't be defined, it's too subjective, who decides it, when should they decide it? I suppose I would see positives and negatives to that. It is an unspecified legal concept, but it has to be clarified in practice. So it's only through jurisprudence, case law, solutions for individual situations, for example in relation to particular areas like the Mental Health Act, that we're going to clarify what's in the best interest of a child. It's an evolutionary concept, like the CRPD in Article 12 of the CRPD. There's projections of knowledge are going to continue to develop, both in relation to the CRPD and best interest principle. We've only had the Convention on the Rights of the Child for 20 years. It might seem like a long time, but for the first time only this year we have the optional protocol to the Convention, which allows individual complaints to be brought to the Committee on the Rights of the Child. And this is actually a great opportunity because it means there's going to be jurisprudence developing in different countries in relation to all sorts of practical elements of how these principles of the Convention are applied in practical scenarios. And the circumstances where we're talking about putting a best interest principle into our Constitution and indeed into our mental health legislation, we shouldn't be afraid of doing that because it's a vague concept. It's going to move on, it'll continue to be applied, but there's kind of going to be probably a sub-criteria that will continue to develop in terms of its significance. It's also, this is just the only technical bit in the whole presentation, it's a doubly subjective concept. So I just wanted to explain that a little bit. Firstly, there's a man called Jan Zerterman who's an international academic in this area, and this is how he sets it out, and I think it's quite helpful to think about it. So firstly, you have collective subjectivity, right? So that means at any moment in history, there's an image of what's in the best interest of the child. And then you have personal subjectivity, and that means that the subjectivity of parents, of caregivers, of legal representatives, of health professionals. And what parent doesn't claim to act in the best interest of the child? I mean, even if it's motivated by some selfish desire, and we see that sometimes in the context of divorce or separation cases, but there is a personal subjectivity in terms of what's in the best interest. Then there's the subjectivity of the child themselves. And problems do arise where the views of the child don't correspond maybe with the views of the parents and other adults in the situation. And then there's the subjectivity of the judge or the administrative authority or the decision maker that's charged with making the decision. So this shows the flexibility and the richness of the criteria as well as the potential and weaknesses. But I think it could be useful to clarify or supplement best interests with kind of rules that apply in various fields. So a good example is in the Mental Health Act, where we talk about what's in the best interest of the child. And some of the principles are mapped out there. It's in the best interest of the child not to be in an adult ward, to be in the least restrictive environment, to have access to information about their care, to have access to an advocate. All of these things, we shouldn't, I suppose my point is that we shouldn't be afraid of this concept and how it is developed. Just to point out, I'm going to finish up now, but I just wanted to flag with you, you'll see in the submission of the Act, the main things, I suppose. We're delighted that the issue of consent is addressed, and certainly we would have supported the Law Reform's recommendations that a 16-year-old should have the ability, should be recognised as having the capacity to consent, along with the concept of the evolving capacity of the child to participate in decision making. The independent advocacy, I suppose, is something that's very important to our members as well. And I suppose peer advocacy was raised as well. It's a difficult one when you're talking about child to child, but certainly young person to child, I think, is an appropriate one. And certainly Headstrong have fantastic youth advocates that have experience of mental health problems, and that is something that would be worth looking at. But certainly we would be very strongly advocating for access to independent advocacy for children. Just quickly then, I suppose, to just mention the admission of children under the Act. Again, the confusion in relation to the Child Care Act, it would be great to see everything in the one piece of legislation, and a situation where a child is being brought into care simply because there's not clarity over whether or not a parent consents to a psychiatric assessment. It's not good practice. It's not good for mental health professionals to have any vagueness about what the situation is or isn't. And I suppose the issue of children in adult wards is still a very significant one for coalition members. And certainly, I suppose, we would like to see a strengthening of the provisions in the Act linked to that concept of best interest, that it's never in the best interest of the child to be in adult facilities or in any facilities that are not appropriate to their care. And I suppose we would like to see a strengthening of that this notion that exceptional circumstances, I mean, there's always going to be, if exceptional circumstances is there, or we have a situation where you can rely or call on exceptional circumstances. We didn't have another bed, we'd nowhere else to put them. But actually, if you map out what those exceptional circumstances are and make them very narrow and put the onus on the state that it is not acceptable to have children in adult wards, I think then, only then will we see a move. And I think the code of practice from the Mental Health Commission has been extremely useful in that regard. But I personally would like to see that strengthened within the Act, the provision in relation to that. So really that's all I have time for. There's loads more in our review of the Act, but again we look forward to kind of digging deeper into the interim report and to the next phase of the consultation process. And thank you very much.